The Honorable James A. Edwards, Judge, presiding. All persons having business before the court draw near to the attention and will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning, everybody. Welcome to another session of oral arguments here in the 5th DCA. As already introduced, to my right is Judge Rand Wallace, and to my left is Judge Meredith Sasso, known as the old 5th and the new 6th. In about how many months and how many days?
3 months, something like that.
Who's counting? All right, we have 3 cases this morning. We'll take a break after the first 2. We're not going to do the coffee break. We're happy to be back in person with everybody, but we'll kind of ease into this whole old routine. So it's nothing personal, but just that's what we're doing today. If you have a noisemaker of any kind, cell phone, watch, anything like that that's going to go off at just exactly the wrong time, please put it on silent so that you don't interrupt your colleagues or the brilliant questioning from the bench here. And each side will have 20 minutes. We typically offer the appellant 5 minutes rebuttal. If you want anything different, just let us know for your rebuttal time, and we'll be happy to work that out. Our first case on the docket is case 21-2681, and that is Charles Beam versus Charles Sane, or Sane, I guess. So with that, if you're ready to proceed, counsel for the appellant.
I'm John Middleton. And your honors, I have a cold. It's not COVID. I've been tested 5 times, but I'm a little bit hoarse, so I apologize if I cough a little bit and everything. It's not serious. It just came hit me this week. May it please the court. My name is John Middleton. I represent Charles Beam. I've been a practicing attorney for 46 years, and I've done a few appeals. And I've talked to law students, and I've talked to younger attorneys, and I've always told them in an appellate practice, don't give the appellate court too many issues, because it just confuses things sometimes. But in this case, I didn't follow my own advice, and we raised a number of issues that we felt that were so stark that we had to deal with them. I know you know the facts. I'm not going to spend a lot of time on the facts, but I think there is some important facts that need to be highlighted in this case, and that is the personal representative was presented with a copy of a codicil in July of 2019. And during that time, Mr. Pravat, who is the beneficiary under the codicil, was calling the personal representative's attorney saying, I got this codicil, I got this, he thought it was a will, but I have this document, and what am I going to do with that?
Mr. Middleton,
Yes.
How did your client acquire his standing?
I'm sorry, sir?
How did your client acquire his standing?
Standing?
Yes, sir.
Well, Your Honor, the argument is very simple. The assignment of the codicil, or the assignment of the whatever benefits in the estate to him should give him standing. Now, the court's argument is, well, he knew Mr. Pravat, who is the codicil's beneficiary, knew about the probate.
Mr. Pravat is not here, correct? Mr. Pravat is not a party to this action, correct?
He is not a party to this appeal, Your Honor. He was a party below. And the point I'm saying is that Mr. Beam, the assignment was not challenged in court as being illegal. It was not challenged in the lower court as being undue influence or anything. That was not an issue as far as the assignment was concerned. The issue was whether or not Mr. Pravat, who is again the beneficiary under the codicil, Mr. Pravat, because of his failure to raise his hand after a purported formal notice, if his interest was no good, the assignment was irrelevant. However, if the interest of Mr. Pravat is valid, then it's assigned to Mr. Beam. Mr. Beam, at that point in time, certainly has standing. And so the point, Judge, I believe that anybody who has an interest in the estate, Mr. Bim's interest in the estate, by the way, is he was living in the house. It has been evicted since, but he's been living in the house. He's been paying on a mortgage pursuant to a contract, and that it alone should give him standing. If you look at your case, as far as interested persons, in the Wheeler case that this court was issued, in the Wheeler case, this court pointed out that a person doesn't have to be an heir, doesn't have to represent an heir, doesn't have to be a beneficiary, but rather what is the effect of the outcome of the litigation on that person's interest. So I suggest to you, Judge, that the mere fact that he would lose his house makes him an interested person and gives him standing.
Didn't he, though, acquire that interest after the litigation commenced?
He acquired the interest after, well, Judge, there was litigation going on. He had a contract with the decedent to purchase the home. There was litigation.
Assignment specifically, though.
He acquired the interest from Mr. Pravat after the litigation, after the estate had been opened.
Why is that not an issue for purposes of standing, based on the principle in Florida law that the cause of action must exist at the time the complaint?
Your Honor, in our brief, we cite to you a case where, if I recall correctly, in our brief, we cite to you a case where it was in, I have to pull that case. But it's cited in the brief, Judge, where in a case involving Perk, the amendment pleading allowed the pleading to be amended to set for standing. And that case is cited in our brief. And when you say he doesn't have standing because of the fact it wasn't acquired till after the estate was open, well, nobody knew about this codicil until after the estate was opened. And it's quite frankly, so you would be saying that if the mere fact that the codicil arose later should cut out a beneficiary of the codicil? No. So it doesn't make sense to say, well, Mr. Bim, because he had that codicil assigned to him after the estate would open, would prevent him from having standing to participate in this litigation. That just doesn't make sense. In other words, the codicil wasn't found until after the estate. He didn't know about it. He didn't have the assignment till afterwards. How does that affect his standing when his standing was acquired after he found out about the codicil? I don't...
Mr. Pravat knew about the codicil.
Excuse me, sir. I'm
Mr.
sorry. My ears are clogged up a little bit.
Mr. Pravat knew about the codicil.
Mr. Pravat knew
From the
about the
time of
codicil.
its creation, he knew of it.
Mr. Pravat knew about the codicil, and he notified the personal representative's attorney, was speaking with him monthly about the codicil.
Mr. Pravat also knew about the action by the PR to open up the estate into probate, and he sat on it for over how long? He monitored the court file for how long?
I believe it was from about a year, if I recall correctly.
It was over a year, correct?
That's what I recall. But, Your Honor, yes, I understand that. But he was in contact with the personal representative. He had not been given proper service, formal notice, as required by the statutes and the probate rules. Why? Because it wasn't served at his place of abode. The court found his place of abode was in Amman, Jordan. He's a service personnel, and he's talking to the attorney for the personal representative, inquiring, but he doesn't have a copy of the physical copy of the formal notice because he didn't have it. And so the issue, Judge, is...
Did he have any doubt that the action was taking place in probate all that time?
He knew the probate case was going on. That's why he was talking to the personal representative.
And he was monitoring the progress of the probate case as well.
I don't think that in the record, I don't recall seeing the progress of the case, but asking about what was going on in the case, and the attorney was saying, I'm not giving you legal advice. And that's what the attorney said.
What was the date of the assignment?
The date of, excuse me, sir?
What was the date of the assignment?
The date of the assignment, I'm not going to tell you that I remember off the top of my head, Judge.
What were the terms of the assignment?
In terms of the assignment, Your Honor, was that Mr. Bim would get any interest that Mr. Pravat had in the estate.
And what was the consideration that was part of the terms of the assignment?
Your Honor, I can't answer that. I'll be honest with you, I can't. That was not an issue, at least that I saw in the lower court, that was an issue of whether or not this assignment was valid or invalid, or as far as consideration, no consideration. Mr. Pravat certainly didn't challenge it. He was in the lower court proceedings, so it was not addressed, in my opinion, by the lower court. But going back to your question, Mr. Pravat was aware of the probate proceedings, and what the lower court found was, well, he knew about the probate proceedings, therefore it excuses the personal representative to comply with the strict compliance with the notice requirements of Florida statutes and the probate rules. And the reason it wasn't complied with was not the fact that his wife got it. The fact is, the personal representative knew that a place of abode where he was living was Amman, Jordan. If that notice had been sent to Amman, Jordan, and his wife happened to be over there, it would probably be good notice. The issue is does actual notice of probate proceedings excuse strict compliance with the formal notice requirements of the statute? In our opinion, the case law that we've cited in our brief, it does not. Otherwise, strict compliance.
Is this really the basis of the trial court's ruling, though, on this issue? Because, I mean, wasn't it more based on latches?
I'm sorry, ma'am. Again, I apologize.
Wasn't the trial court's ruling in this regard based on latches, so that this formal notice in the 3-month period that followed did not really give rise to the basis of the trial court's ruling?
Well, Judge, it was based on latches that nobody raised in the lower court. The appellee didn't raise it. Nobody raised latches. And according to the case law that I've seen and that we cited in our brief, latches is an affirmative defense, and it's waived unless you raise it. And that's what I thought the reading of the law is, and I think that they look at the rules of civil procedure, that if you don't raise certain defenses, they are waived. Latches is one of those defenses. And, Your Honor, so I think my client was blindsided by the court relying upon, quote, latches. And the other thing is, Judge, when you talk about latches, there's a Florida statute that says that a person may bring a later found codicil or another will or whatever at any time during the pendency of the estate. At any time. It doesn't, the statute says that, and I can...
And this kind of goes back to the first issue, that you keep talking about a later found codicil, and that can be brought any time, but your client is relying on an assignment. So the fact that a codicil existed might have been a fact that existed at the time the cause of action was filed, but your client's interests were not obtained until 2020.
Yes, ma'am.
Through the assignment. Don't you see those two facts as separate in terms of interested person, in terms of latches, that sort of thing? The existence of the codicil versus when your client acquired an interest through an assignment to the information in that codicil.
I guess what I'm trying to, my view explaining to the court is that if you start applying latches to a statute that allows the bringing in a later codicil or a will, whatever, at any time during the estate being open, you've all of a sudden limited a party's ability to do so. If you say, oh, you can, except for in the instances where there's latches. And so I don't think the fact that this was brought a year later, whatever it might be, should have any bearing, because the statute says at any time during the estate being open. And by you saying, excuse me, not you, by the court,
Yes.
by the court indicating that, or the lower court indicating, well, latches applies, that makes that statute worthless. If you're going to sit there and say, well, we're going to apply latches when the statute gives you the time period a person can bring it, anytime the estate's open. And so, Your Honor, I disagree with the application of latches when the statute says you can bring it at any time until the estate is closed. I don't care if Mr. Pravat waited till the day before the estate was closed. he shouldn't be hit with latches because he's allowed to do it what the statute says. So I disagree respectfully if you're suggesting that the lower court is correct in applying latches, because latches was not raised as a defense by anybody. And then secondly, to do so would limit that statute, and I don't think that's what latches is for. Latches, when you're talking about latches you have to show sitting on your hands, you have to show prejudice. The court found no prejudice in its order as far as latches is concerned. And I think the court's order is also deficient in that manner. Okay, May, thank you. I have a problem with the lower court's ruling by implying that a personal representative does not have a duty to probate a later found codicil. She says he has a duty to notice people and let them bring it. But I have a problem with it because in the statute says a personal representative's duty is to carry, and fiduciary duty to all beneficiaries, is to carry out the wishes of the decedent, whether it be through will, codicil, whatever it might be. And if you are to sit here and say, well, you know, the PR can get a codicil, all he has to do is notice people that are in that codicil and not tell the court about the codicil, I think that makes a sham out of what happens when we file a petition for administration. In a petition for administration, there is a paragraph that we have to put in there that says, in a testate proceeding, a statement identifying all unrevoked wills and codicils being presented for probate, and a statement that the petitioner is unaware of any other unrevoked wills or codicils, or if the petitioner is aware of any unrevoked wills or codicils, a statement why the other wills or codicils are not being probated. That's what you have to put in a petition for administration. Now, if you're suggesting that if the lower court is suggesting that a codicil that's later found by a PR is not to be brought by the attention of the court, I think that flies contrary to the statute and the rules as they are applied to the probate practice when you file a petition saying there's no, I think there's a continuing duty is what I'm saying. I note that I'm getting close to my time.
Okay, thank you.
Thank you. Again, I apologize for my voice.
Good morning.
Morning.
Michael Kelton, I represent the appellee here, Charles Sane, who's the personal representative of the estate of Sally Kent. He was the son of Sally Kent, the only child of Sally Kent. And I think this court noticed the threshold issue in this case, which is standing. Charles Bem, when he initially appeared in the case, was appearing as an interested party under his claim, but wasn't an interested party. His interests as somebody who had a contract to buy the property would never be affected by the probate. He always had a contract with the estate. No matter what will or what codicil was administered, that interest never changed. Those contract rights would never be affected. It was just a function of who he made his mortgage payments to. The underlying contract was a seller-financed proposed
At
contract.
what point did you raise the standing issue?
Standing was raised in summary judgment, I believe, beforehand, and several times on maybe a motion to dismiss. It was raised before the trial court.
Was it put forward as an affirmative defense?
No, Your Honor, I don't believe it was an affirmative defense. It was certainly raised, I believe, in summary judgment and as a motion to dismiss with the trial court. Mr. Pravat's standing, admittedly, was not raised. It was not necessarily known to us until just before trial, because it was part of a later amendment in October that was kind of slipped in, where Mr. Bem then said, okay, I'm not just an interested party anymore, I'm an interested party by virtue of my assignment from Mr. Pravat. At that point, the pleadings were essentially closed, and we were scheduled for trial, I believe. So that issue, though, Mr. BEM never was an interested party to administer the codicil. He was trying to propose and administer a codicil that he just had no interest in whatsoever. Wasn't a beneficiary. His rights wouldn't be affected one way or the other. He had a contract with the decedent that was not going to be affected. At some later point, Mr. Pravat presents a codicil to my office. We, pursuant to the court's instructions, put him on notice. It's just...
The court, you didn't put him on notice as the formal rules and statutes require, though, did you?
The issue with the place of abode and where notice was sent, because notice was sent to Ruskin, Tampa.
We all know where it was sent and where he was.
Correct. He was, and I believe the conversation in the email, it's all luckily memorialized by email. In the email, it's pretty clear what the intent was, which is we're going to mail you something. She flat out said, we're going to mail you documents with the understanding, or like paralegal's understanding
The
that
question was, what's your address in Tampa?
because,
When your paralegal knew he was in Amman, correct?
and if that was not the correct place to send mail, then that would have been for him to easily receive mail.
But he should give y'all legal advice when you refuse to even tell him what to do with the codicil?
I don't think it would have been legal advice to say where he wanted his mail sent. I think that the way that transaction and that conversation took place, if you ask a reasonable person, or if you ask anybody, hey, I'm going to mail you something, what's your address in Tampa? And they didn't want their mail to go to Tampa because that's not where they would receive it normally or where it's convenient, they would say, no, I'm not in Tampa. The better place to send it is here in Jordan because I'm going to be here for another 2 months.
Well, Mr. Kelton, I think that the actual email, the text of the email, can you please confirm your current address in Tampa? ? I understand that you are still deployed, but your wife can sign for the certified mail. We just need to know, was it sent and received?
Okay, and just before then, she explained to him why we need that. The court wants us to send you all notice of all the pleadings, notice of administration, and again, the convenient place would have been, we're going to send it to Tampa. It was maybe an incorrect assumption per the letter of the law, but if, for purposes of notice, of actually putting him on notice, if that was not a place for him to receive notice to get legal documents, then at that time, that was Mr. Pravat's point in time. He's the only one that could have said, no, I live here. Mail comes very easily to Amman, Jordan. Send it here. Don't Tampa. I mean, there was very easy correction he could have made. Instead, he gives an address in Tampa, knowing that the legal documents are going to be sent there, and then now wants to argue, oh, no, why didn't you send it to me in Jordan? Well, the argument at trial they made was, well, his wife never actually opened the documents. And then when he got home, he never looked for the documents. They couldn't find them. They never went back and contacted us. So there's no assurance that if we had mailed them to Amman, Jordan, he would have actually read them there. I mean, the position that appellant is taking is that we were somehow under a duty
Take the
to...
position that there should be a estoppel applied in terms of that Pravat essentially made a misrepresentation of his address. In other words, he lied about his address, and that y'all were somehow, hang on a second, and that y'all were somehow prejudiced. I mean, those are the elements that have to be. There has to be a change in position and prejudice. Forget about whether it was a misrepresentation or not. What was the prejudice in him telling you to send it to Tampa to your client?
Well, the prejudice now is that it's being used against the estate as, well, we didn't get notice.
All right.
I mean, at the time, is that...
And latches as well. What was the prejudice to your client that would bring latches into play?
At that time, we were trying to close the estate. I mean, we were doing everything we possibly could to close the estate.
You were aware of the codicil, and everybody, I think, doesn't everybody agree that the codicil was properly, formally, validly executed?
Yes, Your Honor.
And, I mean, if you turn back the clock, that's really what should have been probated, correct?
That with the will named a PR and named my client as sole beneficiary, the codicil was specific as to a piece of property. So
Right,
the will,
which was the main asset of the estate.
correct. Well, there were other assets. Yes, it was the main asset.
It was an important asset.
It was probably the main asset. I mean, you're correct. At that time,
And by not probating the codicil, the personal representative got to keep that property. Had the codicil been probated, he would not have had the property, correct?
we haven't closed the estate, Your Honor. There are claims. I mean, there's no guarantee right now that the property very likely will have to be liquidated to pay claims that have been made against the estate. So, no, I mean, we've tried to close the estate. The only way to do so would be to sell the property, liquidate it, and pay the claims. There's significant claims against the estate, but we've been unable to do that because of ongoing litigation from Mr. Bem, who was living in the property, and then this. So we were trying to close the estate and pay the creditors, which is also the duty that the personal representative has to pay the creditors. The number one asset that had value to be able to pay those creditors was being tied up in litigation. So when a year and a half or a year after the estate is being probated and a codicil jumps in, yeah, my client, the PR, is prejudiced, or the estate is prejudiced, in that we can't pay the claims that are valid and against the estate. Can't wrap it up, can't distribute assets, can't pay claims, can't close it out. He was aware of the estate and the probate from day one. He was aware that she passed away. He was aware of the administration of it. He had contacted my office several times before acknowledging the codicil, and then before even sending us a copy of it. And then even then, more time went before he presented the original to the court. At that point, we put him, before he put the original in the court docket, we provided him notice. Here you go, here's, the notice, let's send you the paperwork. And we waited, and he didn't do anything until later he did an assignment, but then also tried to administer the same codicil even after he had assigned his rights to Mr. Bem. Mr. Bem never amended his pleadings to include his assignment, so the relation back doctrine, he would have had to dismiss the petition and file it new, because he lacked standing when he filed his amended petition to administer the codicil. And that gap in time, I think, is what is detrimental to the administration of the codicil. They just lack standing.
Going back on latches, do you think it's problematic that this is, an element of the application of latches, this prejudice component, and that finding wasn't made by the trial court? One way or another.
Yes, it's and admittedly it wasn't argued. It wasn't raised as affirmative defense. The delay was raised under the statute, not necessarily latches. That he's been put on notice. He's had his 3 months. Here we are.
But the 3 months isn't supposed to start until there's service, correct?
Correct, Your Honor.
And there was, again, we know the judge decided the issue more on latches than formal service, or you can say as an alternative. But if the 3 months never started because there was never service, how could latches come into play if the clock never started?
Agreed. Our position is that when he received notice in Tampa, that's an unusual case. There's no case law that discusses when the beneficiary has provided an address. Then you're right. If there was no proper service, then latches doesn't matter. He was never put on notice. But if the inverse were true, if we had contacted him and said, Mr. Pravat, we need to send you formal notice of the estate. You're living in Amman, Jordan. What's the address there? If he had said, no, please send it to my house in Tampa. That's my wife. I'm going to be there in a month. We didn't send it to the normal place of abode. Would he then be allowed to come in now and argue that, hey, I didn't know the legal ramifications of that. You didn't send it to my normal place of abode, when he clearly told us where to send the mail to. They said, no, send it to me here. So this is not that explicit, but it's pretty close. If we look at it, the clear intent was, we have legal documents that we're sending you that the judge has instructed us to send you, assuming that Tampa was the easier place for him to receive that. We're going to send it to Tampa. And if he wanted his mail in Jordan, that was the time to tell us. If we had said Jordan and it never got there because of mail issues or because his deployment ended and he was coming back home, would you make the argument that, well, why didn't you send it to me in Tampa? Because my wife's there, she could have signed for it. And then again, I think there is an issue that there's no guarantee that he was going to open those documents, read them, and see, the deadlines and the reason why we have formal service. Formal service requires.
Well, Mr. Kelton, you're stacking speculation on top of speculation.
I don't mean to.
So there's a lot of talk. I've heard you talk a lot about, sending the documents to Tampa and latches, and your client is looking the other way when he's clearly aware of a codicil your best argument, I think, and your only argument really, is the appellant in this case is not an interested party. Is that correct?
I believe
Everything
that,
else just sounds to me like you're trying to do a lot of backstroking and making excuses for why things didn't happen. But ultimately, what it comes down to is he's not an interested party.
I believe that the threshold issue, and I addressed it in the answer brief, is that there's lack of standing because he's not an interested party. And before the assignment, he was not an interested party, and then after that, he was not an interested party because of what was assigned, because of the defects in the assignment itself.
I'm sorry, why wasn't he an interested party after the assignment?
After the assignment,
Yeah.
because of the, he sat on his rights because of codicil, the service issue in Amon Jordan. Again, I acknowledge, Your Honor, that assumes that service was correct, which we believe, given the unique facts of this case, it takes it outside of those other cases. Certainly, he provided an address for us to send mail to.
In the briefs, there's discussion, and in the record, that Mr. Privat asked what he should do with the codicil, and he asked you or your office what he should do with the codicil, and the response was, we can't give you legal advice. Is that an accurate?
I believe it's in the record, Your Honor, but I never spoke with Mr. Privat.
No, I'm saying you
Yeah.
or your office. I'm not saying you personally.
I mean, that would be any time somebody, yes, I mean, that would, I believe, is what my paralegal instructed him, was, we're not your attorney, we represent the personal representative. We really can't tell you what to do or not to do with it.
With a codicil that should be, according to law, should be filed.
At that
right?
time, he didn't have the original, wasn't aware where the original was. He just mentioned it. We didn't really believe that it existed, if, in all honesty, Your Honor. He never provided us a copy of it.
After he provided a copy, did you ask him for the original?
He then, I believe, had to get back to Tampa, and then once he got back to Tampa from his deployment, he then filed it with a court record in the docket. And at that point, it was shortly after that, we had a hearing, and the judge said, set him formal notice. No, that's not right. I take that back. When we received a copy of it, he was in Jordan. The court said, put him on formal notice. He was put on formal notice. Sometime after that is when the original was filed with the court record. We've never had the original in our possession.
Right.
I think the argument also that was made that there's a 2-year window or when the estate is closed for a later found will or codicil, I don't believe it's accurate to define this as a later discovered or later found. It was always in somebody's possession. It wasn't in a safe. It wasn't in a lockbox. It wasn't within some documents. Mr. Privat always had it. He always knew where it was. He always knew of its possession. It's not real accurate to call it later discovered or later found. It was in his possession. So if it's in your possession, you can't then say, well, I later discovered it, so I get the full effect of that 2-year statute, the 2-year window for the statute provides, or until the estate is closed. He didn't just discover it one day. He always had it. He always knew about it. He was always aware of it. It's hard to call that later discovered. I think that's would only be the situation that gets you to fall under that statute specifically. So with that, if there's any other questions.
Okay, thank you.
Thank you.
All right, Mr. Middleton, you've got about 4.5 minutes for your rebuttal.
Yes, sir. First, on the issue of standing, estoppel. There's standing, estoppel. There's 3 issues that were talked about by, 2 issues that were talked about by opposing counsel in his brief that were not pled as affirmative defenses, and one of them is estoppel, and there was talking about fraud too, if I recall correctly, in his brief. Those are affirmative defenses. They weren't raised. The only affirmative defenses that were raised was unclean hands, if I recall correctly, and there was another one, but it was not standing, estoppel, or any of the affirmative defenses that we're talking about.
Do you think that's kind of irrelevant as to standing, though, in light of this court's Weimaraim case that characterizes the interested person status, which we're kind of conflating with standing here, as an element of the case based on the statutory pleading requirements?
Your Honor, as far as I was looking at the Wheeler case, which is Wheeler v. Powers, 9727 2nd 278, which states that an interested party need not be an heir or represent an heir, rather a person has standing when he has a sufficient interest at stake in the controversy which will be affected by the outcome of litigation.
And that's defining interested person, but in terms of whether or not it needs to be pled as an affirmative offense versus,
I think that it should have been raised below, but Judge, if you look at the record, there was a stipulation that Mr. Bim was an interested person. If you look at page 88, if I recall, page 88 of the transcript of the proceedings, the court, you are an interested person as you stand there today and as of the date of the assignment. That's what the court found, and it certainly was not raised. This was a trial. There was a pretrial order or compliance that stated what issues were to be tried, and standing, and that was not raised as an issue.
You didn't raise standing in your initial brief in this case, did you?
I think that
I think you raised it in your reply, but you did not raise it in your initial brief. So haven't you waived that argument in front of this court?
I was replying to the opposing counsel. I have argued that in our initial brief that my client has is an interested party, either as a creditor or as an assignee of a validly executed codicil.
So what you're saying is standing was never argued in front of the trial court?
That's what I'm suggesting to you, Judge, and that it was never argued. Neither was laches.
Was interested party argued in front of the trial court?
Not that I recall, Your Honor.
Because you didn't raise that either in your initial brief.
The interested party was, again, the trial court stipulated that my client was an interested party at the time of the assignment.
I mean, finding one, Charles Beam is not an interested party entitled, that's the first finding in the final judgment.
Well, I get that, but what I'm suggesting to you, Your Honor, is the court made a finding contrary to what she stipulated to on page 88 of the transcript that I just read to you.
So why wasn't that argued in the initial brief then?
Your Honor,
It was clearly teed up by the trial court, and you're saying that the finding by the trial court was directly opposed to the evidence that was put before the trial court.
I think what the trial court did, Judge, and I think we did argue in our brief, is that the trial court found that Mr. Pravat's codicil that he presented, that the fact that he did not respond, that he had personal knowledge of the probate proceedings, not necessarily the time period, but the probate proceedings, that once that happened, that made his latches applied and the codicil could not be presented. Therefore, any assignment to Mr. Ben took away any interested party status. In other words, if Mr. Pravat's codicil is no good because he had noticed it and he didn't pursue it, certainly an assignment of that codicil does not give Mr. Bim any more rights than what Mr. Pravat had. And that was the court's argument, that Mr. Pravat was too late in pursuing the codicil, and therefore Mr. Bim's interest was only what Mr. Pravat could have given to him, which was nothing if the court found that the codicil should not be probated. I hope that does. Am I making any sense to you there as far as what I thought was the judge's ruling?
I appreciate your answer.
Yes, sir.
Thank you. The red light's on.
Red light's on, sir.
Appreciate it.
I'm going to finish up, Judge. I think we've said enough. Thank you so much.